Before getting into the session, let's understand what are the most common legal issues you guys face. Or do you look into the legal issues at all, or it's like alien language? I don't want to touch upon that. It's too early. Let my founder look into it. You know, let me not bother around it. So, any queries you have? What are the most difficult issues you face? One, the language. Yes, I understand that. So you would have seen many times, when most of the projects, first of all, don't look into legal issues at all. But the problem is, ignorance of law is not an excuse. So, and there are many pitfalls when you don't look into the legal aspects. So broadly, if you look at, there are various issues, which is trademark issues, copyright issues. Then there are patent issues which you will face, and that will affect the whole project itself. It will derail the whole project. So it is very important that as a community, we all look into, in any open source project, for the longevity of the project, we should look into all the legal issues. And they are not too technical. If technical people can do various things, yeah. So, can you go to the next slide? Yeah. So the disclaimer: this is not a legal advice. Next. So these are the broad things we will be covering today: copyright, trademark, and patent. Okay. And I'll also provide you some solutions so that you don't have to worry about all those solutions. There are various platforms where if you are interested, you can read more about it. And many of the cases you would have seen yourself those issues when we talk about it. Yeah, next. Okay, so now let's understand the most important part of IP, which is copyright. And you would have seen this in this form at various places. So this is an example of Apache Software Foundation's. How do they put copyright? So when you see 2000 and to 2022, it means that there was copyright generated from 2000, the year 2000, and it's been continuous. And so what is so it's an exclusive copyright. What is it? It's an exclusivity which you have provided. And so what is the exclusive right you have? You to control copying, modifying, and distributing a work. But if you see open source, we have copyleft licenses. So, which is a shift from the copyright. Okay, so there are some changes in when we talk about copyright in the open source parlance, because you have copyleft licenses. So broadly, it will be two things in any contribution you would see or any project. Two legal issues from a copyright perspective. One will be the licensing information, which you should provide, and the other is the copyright notice. And many times you would have seen people take away the copyright notice or the legal, the license information. That is very dangerous. If you're copying any code from any place, please make sure that the copyright notice and the license information is taken from there, understood before applying. For example, there is incompatibility between a GPL license and MIT license. Okay, so, and there are various obligations. Let's say a GPL3, there is a patent obligation in that. So you may not be able to use it in a commercial project. So it is very important that what is the background of these licenses you should understand before you copy. And as I said earlier, ignorance of law is not an excuse. And you will face the music later on. And later on you will not realize which license it was, if you had not copied it correctly, if you omitted to copy it, and understood the importance of that license. So, a copyright holder can be even a trust, an individual, a project, okay? And unlike other IP, copyright need not need a registration in India. So the second you put a copyright notice, this is a copyright notice, copyright C, a circle, and the year it was created. So if you have created it over the time, So in this case, it has been created from 2000 to 2022. So that is what it signifies. And next will be, if you're a company, then you will put your company name, let's say Dash Private Limited. Or it's a foundation, you will put the foundation's name. Because downstream users will understand who is the copyright owner of this. So in case they want to they want to do any modification, then they can look into the company's guidelines and what is the license it is based on. All those information, they can go back and check into that organization. So it could be a legal entity, it could be a trust, it could be a foundation, it could be a company. Any of them. Okay? Next slide, please. So why is the copyright notice very important? Because it gives an understanding of the rights and obligations which each person has to use. So for example, you would be a user. So when you see a copyright notice, you should understand that, okay, these are my rights and obligations. Very clear. There is no confusion there. The other thing important is the license information. As I earlier told you, these are the two most important documents which is a must in any open source project. It is a must. Because that tells you your rights and obligations. Whether you are a user, you are a creator. Because if you are the owner of the open source project, or you are the maintainer, or what is your role is in that project, that will give an information to the downstream users, what are their rights, what are the rights you want to give them. All those things are to be provided. That's a must. So the other most important thing which you will find is the contributor's license agreement or a developer's certificate of origin. So I have seen in my experience, many times when projects, when they're just starting off their open source projects, they go for a CLA. And developers don't like CLA because legal jargon, sorry, I don't understand it, so I don't want to contribute it. So it is very important that at least if you don't have a CLA, at least a developer certificate of origin. And what is the importance of these two documents? So two things. One, I can only contribute to any project or any give a copyright if I own myself that copyright. If it is original. I can't copy a piece of code from somewhere and say that, okay, I am the owner of this copyright. No. The second it is created, the piece of code is created, that person is the owner of the copyright. Unless he is working for a company where he has given that right of ownership to that company. But otherwise, the creator is the owner of that copyright. Let's say you write a piece of code, that you are the owner. And if it is original, you are the copyright holder. And you have certain rights with it. So once that right is only there with you, you can contribute to a community or a project or whatever it is. So it is very important that at least the basic document of a DCO is there. Secondly, the reason for all these things is also, let's say this project which you are contributing, few years down the line, do you want to change the license for whatever reasons? Then contributor's license agreement is very important because that gives the right to that project to change the license. Because you are giving up your copyright to that community or that project, and they have then the right to change the license. So these two documents, either of the one, is very important. So DCO, Developers Certificate of Origin, originated from the Linux Foundation, okay? And this has, if you see projects which are corporate sponsored, you will find mostly contributors license agreement than a DCO. Smaller generally go for a DCO. But these are two a must document. Either of the one. Next, please. Okay. So now we'll also look into the trademark. So when you use the word trade, so you could be into a service or you are having a product. Okay. So it gives you, let's say I use any trademark. Let's say I use Microsoft, which is a trademark, or Google, which is a trademark. When I use that, you understand there is a quality of that product or a service. if they are whatever they are providing. So there is an origin. Okay, when we say okay Google, so it's you can relate it. Okay, there is a company Alphabet which owns all this trademark. There is an origin. There is a quality. There is an inference of the source. Okay, same way in an open source project, this is very important. And I will also showcase to you later in the day, in the talk, that how companies' projects have been affected because of not enforcing these trademarks. Unlike copyright, trademark enforcement is very important. So what does it do? It avoids confusion. So it's like naming. Like we all have individual names. What is the reason for having individual names? To differentiate between the other person. So the same way, in any project, you should have a trademark. And also you should have a trademark policy. What are the rights how that trademark can be used, where I can't use the trademark, all those things has to be there in the trademark policy. So when you look here, the trademark owners have to protect their mark. So for example, there is some misuse. Let's say some downstream users are injecting a malware into your code base, into your project. And because of which your reputation is at risk. Okay? So you should be very clearly state in your trademark policy what are the do's and the don'ts. In plain English language, you don't have to use legal language. And you can see how good projects, and so that's also a hallmark of a good project is that they have all these policies very clearly in their documentation. So two things you need to have. You need to have trademark. You need to have a trademark policy. It could be simple trademark policy. And as you are all aware, trademark is jurisdictional. So if you file for a trademark in India, you can't protect it in other regions of the world. And trademark works in classes. So there are various classes of trademark. So you, for example, you have a service. There is a service mark. If you have a trademark, then you have a trade. You are in different sectors. You have various classes. Like for chemical, there is a different class of trademark. So you should be careful about that. So as we have already discussed, the importance of trademark is to avoid confusion. There is a quality, an origin, and you like for example, you think of any trademark, Coca-Cola. You know that okay, this product has an origin, this has a certain quality, and this is in certain sectors. So most important problem when we think of trademark is when you have in all open source projects, you have distribution and modification. So let's say I do modification downstream and I still use the trademark of the project, of the earlier project. And let's say I put some malware or the piece of code is, violating some other person's copyright, some company's code I have put in there. So all those are issues which any open source project should be watchful of. Because if you are not watchful of, you would end up in litigation. And the reputation of the project will be an issue. So it's very important that you take care of all these issues very seriously. And you have to ensure that if somebody in the ecosystem is coming with a similar name, you should write to them immediately and say that we have a copyright, we have a trademark on this subject matter, please don't use this, because this will create confusion. Yeah. So, and trademark enforcement. So as I said, if some other project or any entity is using your trademark, you should write to them and send a cease and desist notice so that they are not creating confusion. And in your trade name, they should not be taking the advantage of. So the examples are here. So Debian and Mozilla Foundation had issue relating to the Firefox trademark, which started in 2006 and ended in February 2016. So you can think of it like for 10 years, this issue was happening. Despite the fact that Mozilla Foundation had a great trademark policy, but they did not enforce it. It took 10 years for them to enforce it and settle it off. So it's very important that, foundations not only have their policy, but they should also enforce it. Otherwise, it's of no use. The other good example is Elasticsearch and Amazon. So Elasticsearch had to sue Amazon because they were using the word Elasticsearch, and the allegation of Elasticsearch was this, that this is disables certain functional available from Elasticsearch and includes software code not offered by Elastic in any Elasticsearch product. So all those issues you would find here, if Elasticsearch had a proper trademark policy, this could have been avoided. And you know what has happened after post this. So it went into a settlement. Now let's look into the other cases where we have seen these issues coming up. Java, this is a good example of how Oracle. So here, the other interesting part is that now later on Eclipse Foundation had to ask the community at large to propose names. And just think of it. You have to change name, which creates confusion. It is a lot of cost because you have to publicize the new name and also see that the new name is also not violating some other trademark in the ecosystem across the globe. So it is very important that when you choose a trademark initially itself, you should do a thorough trademark search so that it is not confusing. It is not used by some other ecosystem anywhere in the world. And also, once you have a trademark, you should also have a trademark policy, and you should also enforce your trademark. If there is any misuse, any violation, immediately send a cease and desist notice. Contact a lawyer and send a cease and desist notice. Because if you don't do that, then there is a brand dilution. And you could be liable because people think that, okay, this name, Mozilla, this name is owned by, this trademark is owned by Mozilla Foundation. So they will reach out to Mozilla Foundation, not to the person who has created havoc in the code base or injected malware. So you are responsible for the this one. So that creates a lot of confusion in the ecosystem. So it is the interest of the trademark holder to prevent the use of name which may confuse the ultimate user. So it is your obligation to do that. Now let's look into the other most important part, which is, so open source projects across the globe don't believe in patent filing. But that doesn't mean that the open source community and the ecosystem is free from problems. So if you see the preamble of many of the licenses across the globe, let's look at the GPL preamble. Any free program is threatened constantly by software patents. We wish to avoid the danger that redistributors of free program will individually obtain patent license, in effect making the program proprietary. To prevent this, we made it clear that any patent must be licensed for everyone's free use or not licensed at all. So this is GPL's preamble. And if you see Apache 2.0 also, there is an explicit statement there. That there is an explicit statement that patents is not there. And you get a patent license, worldwide perpetual. So from this you understand that across the globe, open source projects don't believe in patent filing. Because you have to get license to each of those persons. So that's the whole broader understanding. But that doesn't mean that the whole ecosystem is not punished for not filing. Because see, you don't have any patents, that means other companies and ecosystem players. So there are a whole ecosystem called as patent trolls. What are these entities? They buy patents. They don't have any product or services. They just buy patents. Then they sue the whole ecosystem. So it could be an open source project, it could be an open source foundation, or it could be a company, it could be a startup. So what they do is, they are called patent trolls or patent assertion entities. So the whole open source community has been sued many times. The one best example, which was the most recent one, was Genome Foundation, which was sued by Rothschild. So when Rothschild sued Genome Foundation, it was for a Shotwell, which is a photo manager, which according to Rothschild, infringed one of their patents. So what Genome Foundation did was, being an open source foundation, they joined the open source open invention network. I'm one of the persons who is part of open invention network. So once they joined the community, what we did was we provided them prior art. So what is prior art? So prior art, once you have prior art on a patent subject matter, then there is no novelty left in that patent. And one of the fundamental reason for any grant of patent is there is need to be a novelty. It has to be a novel idea or a novel invention. So once there is prior art, then there is no novelty left, and you can invalidate the patent. So using the prior art provided by Open Invention Network, Genome Foundation went to invalidate the patent of Rothschild, which Rothschild never expected. Because finding prior art is not easy. And secondly, generally open source foundations and communities don't retaliate. And, but this was an exception. And what you see is it was settled. So it was filed in 2019, and May 2020, it's one of the fastest settlement happened, because what happens is if Rothschild's patents is invalidated, then they can't sue anybody in the world using that patent. So it made sense for them to settle with Genome Foundation and move forward. And few years, I think last year, this patent was invalidated by another player. So this patent is invalidated, and now this patent troll cannot use it against anybody in the ecosystem globally. But the most interesting part which I found of the settlement statement was, from Mr. Rothschild was, I'm pleased that we have managed to settle this issue amicably. I have always supported this innovation of open source software and its developers and encourage its innovation and adoption. So this he's making after suing an open source foundation. You know, he's a good guy. So yeah, so now let's talk about, so yes, we have seen that, you know, the ecosystem can be sued. The ecosystem doesn't believe, open source project doesn't believe in filing for patents. But is there a defensive strategy? Because filing for patents is an offensive strategy. But do we have an ecosystem where we can ensure that there is safety on usage of Linux and open source? Yes, there is. So Open Invention Network is the answer. This community was initiated years back, almost 16, 17 years back, when IBM was sued by a company called as SEO. So when IBM was sued, as you are all aware, IBM has the largest collection of Linux platform patents in the world. This was finally settled. SEO is no more in existence. This company is no more in existence. But that created a thought process in IBM's mind that the fundamental technology, which is Linux and open source, needs to be protected. Because what will happen is, otherwise there will be patent fights. And fundamental technology, the money which should have been spent on innovation, the money which should have been spent on employees, would be spent on litigation and in courts. So the objective of Open Invention Network is on fundamental technology, which is Linux and open source. We say fundamental technology, we are talking here about on Linux and open source, 3,885 softwares and applications, which includes Android, all those softwares and applications which we use in our daily lives. All this is protected, so anybody can join. You could be a project, you could be a startup, you could be a company. There is no commercials to join in the community. Secondly, we also have a defensive war chest, because the whole ecosystem faces two problems. One, operating entities behaving like a patent troll. So what are operating entities? Operating entities are any entity which has a product or service. Okay. So any company which has a product or service could sue another company or a startup or a project and assert their patent. So in that case, what we have is, what is the difference we have is, we have 1,000+ patents across the globe, global patents, like US patents, European patents, and Chinese patents, in all areas of technology. Not in one area of technology. We have blockchain patents, we have biometric patents, medical technology patents. All this acts as a defense. So let's say one of the community member is sued, or a company which is outside the community is sued, then in that case, we can, once they join the community, we can lend this, any of these patents, which that company which has sued one of the community members, which is they are infringing upon, we can lend it to them and they can counter sue them. So there is a counterbalance created here. As I told you, this is in all areas of technology across the globe. And most of the patent litigation happens in US market. Europe also has seen a lot of litigation. So that's what we do. And we have also foundations like Linux Foundation, various other open source projects which are part of the community. So this acts as a defensive strategy against patent trolls. So the other thing which also has happened over the time with Open Invention Network is, all these years we were never doing a counter litigation. So what has happened in the recent past is, we have tied up with another entity which goes and challenges and invalidates patents of patent trolls. So it's called Unified Patents. So Unified Patents has an open source zone. In that zone, they go after entities which are patent trolls. They sue them and invalidate those patents. So with that, I think I will have to say thank you. I think my time is up. And in case you have any questions, feel free to ask me.
You can use the mic. Check 1, 2.
Yeah, I understand that. Yeah.
It's like, and finally at the end, there is probably a specific license which they suggest to choose, or maybe it will just create, like, without going and reading everything, it will just generate a license and we can just upload that file.
See, to answer it in one line, I would say that, see, each factual situation is different. See, why was this licenses created? Let's say after the Amazon litigation, Eclipse has changed, not Eclipse, the other company has changed its license. So when you have started the project, your intention was to accommodate the whole ecosystem. But then there are players like Amazon which might create, put it in the cloud and close source it. So each of the situations you have to foresee, and these are good examples of what not to do in open source, what projects should not do open source. What are the mistakes other foundations have done, what should be done. So that's the reason why, it's something which you have to do.
We have to do.
Yeah.
Okay.
It's like, sometimes you don't like certain subjects, like maths, but you have to,
I like
Hello, sir.
Yeah.
Actually, we are from the open source compliance team.
Great.
Some of the repositories, they are not well maintained with license and specific sources versions. For example, the Microsoft itself, there are some DLLs. The Nugget package library itself does not have the proper license, and the source is also not available.
Yes.
So in that case, we usually disapprove those kind of components whenever the developer use that, and we will disapprove that. So what is your point of view as a legal, what is your suggestion in that
Yes,
case?
you are absolutely right. We should not be using those projects and pieces of code, because that will put you in various risks. So I'll give you an example. A few years back, Equifax, there was a huge data breach. Immediately they blamed Apache Struts because they were using Apache Struts. What happened was, they did not do the patching of that vulnerability, and the blame was put on Apache Struts. So if any project you are using, any piece of code you are using, you don't find license information or the basic copyright notice, you will be in a soup if you use those pieces of code. So it's better to stay away from those pieces of code, because you will be incurring liability, or and this is a community. So disrepute will follow you if you are using such pieces of code. And where you know that there is some shortcoming, like license information and copyright notice is the basic things. And when you look at from when we look at from a rating of any project, Like Linux Foundation also has a project where they look at the from a security perspective, vulnerability perspective. In those cases, we see that such are the red flags where we should not enter into. Those projects, those pieces of code, please don't use it.
And one
You
more
will
thing.
get into legal risk.
Okay. And one more thing for the legacy code, sometimes if you found some kind of public domain or the GPL, so actually it's a legacy code, the developer don't want to change sometimes. So what is your suggestion or how to deal with that in that case, the compliance?
Legacy codes are, if you're looking into the banking sector and every sector, I think not just banking sector, all those sectors you'll find legacy codes. So either you use those pieces of code, but you are at risk because there might not be many of the information which is required for you. And legacy codes are also the best places where you can have malware attack and hacking. So you always have to see projects which are most updated, where there is more contribution. And if you have a chance of using that, then you should use that. But as long as possible, avoid using legacy codes. Because there is no support, there is, there will be various risks which will be involved. It could be vulnerability issue, or it could be anything.
Thank you.
I'll come out,
exactly.
we'll answer all those questions outside.